Thank you.
That's very helpful. Thank you.
I like it.
Good morning. My name is Amanda Rivera. I'm the hearing examiner presiding over today's case. The date is September 19th, 2024, and this is case DCI 2024-00015. It's a MHPD amendment in the North Fort Myers planning community. Because this is a quasi-judicial hearing, all evidence and testimony must be taken under oath. So if you intend to speak, if you could please raise your hand. Do you swear or affirm the testimony you will provide is the truth?
Yes, ma'am.
Okay, thank you. So the matter that will proceed this morning is first we're going to hear from the staff, the applicant. I'm looking at the staff. They will present their request in the case and call any witnesses that they may have in support of that request. Following their presentation, we will hear from the county staff who will present their review and recommendation. In this case, they are recommending approval with the same deviation that was carried forward from the last case. After we hear from the county staff, then I will call the public comment cards that I have in the order that I have them. There is no time limitation. However, there is only one opportunity to speak. So I encourage you to take notes as we go through things this morning to make the most of your time at the podium. Once we close public comment, we'll come back to the applicant and the staff for their rebuttal and their closing comments. I will then issue my recommendation to the board, who will have their final hearing on the matter. If you want to speak at the board hearing, you must speak at the hearing today, and your comments at the board will be limited to the substance of the comments that you make at the hearing today. And if you want to receive a copy of the recommendation but not speak, you can do that as well. Just fill out the card and indicate that when I call your name. So with that, we are ready to begin whenever the applicants are ready.
Thank you. With that, we'll call Mr. Kelly Klepper.
Good morning.
Good morning. If you could present at the podium, please. Thank you.
Absolutely.
Good morning.
Good morning. For the record, Kelly Klepper with Kimling Horn and Associates. It is a pleasure to be here before you again on this project. Just a little bit about my background. For the record, I've actually been a certified land use planner. I'm a planner with over 32 years of experience serving a broad variety of municipal and private clients across not only Florida, the west coast of Florida, but also across the southeastern U.S. I have the pleasure of having worked on this project from its inception on. So a lot of the case history that we've talked about and been involved with, it's been really nice because of the consistency and the continuity between the projects and the team and working through this process. I've also been recognized as an expert in this group here with this office as far as the hearing examiner in these cases as well on multiple occasions, and also been recognized as a land use and planning expert in other jurisdictions across the state. And also been recognized more recently by the U.S. Department of Justice in a federal rails to trails takings case that was recently resolved in favor of the Department of Justice as well. So broad variety of expert witness testimony, as well as recognized as a land use and planning expert in my field. So what we're here today to do is to talk about what we call a minor modification or a minor amendment to the previously approved project. This application for this phase of Pine Lakes was actually approved a little over 2 years ago. Fairly lengthy process working with staff on the review and the update and the expansion of the facility that we're now talking about today. And there again, this was recommended for approval by staff, and it was subsequently approved by the Board of County Commissioners as part of what you see here, which is Z21022. And that was there again, that was back in May of 22. There was, like you said, the one deviation, the modification that we had identified at that time, and we're carrying all of that information forward as we speak. At that time, we were also working with the Florida Department of Transportation with respect to access. Ms. Becca Bond, who is a licensed transportation and traffic engineer, will be speaking about the status of that. But there are a number of permits and applications that are still working with the state as we speak. To kind of give you a little bit of a understanding of where we are in the world, you can see the majority of the property on this aerial, of course, the Pine Lakes Country Club. That is outlined in yellow. That's the existing development. The area to the north, that kind of the sliver, is the expansion area that we've been working on, like I said, there again, as part of that previous approval back in 2022. At that time, there was a lot of discussion, especially with respect to access and stormwater and compatibility and consistency and buffers. all of which were found to be consistent, and this is something that Peter and I are both here to testify about as well, being found consistent with the Lee Plan. The Lee Plan, of course, is the county's comprehensive plan and that overarching guide that, regulating and setting the stage for growth and development within the county. So what is the specific request? Again, this is a minor amendment to the previously approved PD to relabel, in essence, to add a word that was in the previous traffic studies with respect to emergency access. The previous concept plans and plans that were approved noted that there was a right in, right out at that time. Traffic studies and everything that we've been working towards identified those as an emergency in, but still resident being able to exit or egress the property. So in order to be consistent with that terminology, and also in working with the Florida Department of Transportation, we do need to add the note or that nomenclature saying that it would be an emergency right in, but it would still be resident out at that point. So emergency in, full access to our residents exiting the property. Two other things that are definitely of note here is we have identified and also defined and increased the size of one of our lakes, and I'm going to show you that on one of our plans here in a second. So we've increased the amount of lake and open space as well as the stormwater. But more importantly, we've also made a reduction in the property. Previously, we were approved for up to 400 units. Based off of where we are today with some preliminary engineering and also the stormwater and some other things, we have reduced that number down to 336. So you're talking about a significant decrease in the number of units as well as the overall potential, I'm not going to call it impacts, but impacts on infrastructure. So reductions in traffic and transportation, reductions in water and wastewater, reductions in impervious areas. So there again, reducing the footprint of this project through this process.
Not to stop you, but for a moment, that was my first question I was going to ask you, because the DO, it looked like, was proposing the 336, but the conditions still talked about 400. So is the intention to change the 400 down to 336? Okay.
Yes, ma'am.
Thank you. And but for the nomenclature of the emergency, would the other items that you're doing with respect to removing the internal right-of-way and increasing the lake size, would those warrant a public hearing for us to be here? Could that be handled administratively but for this amendment?
My understanding is absolutely.
Okay, thank you.
Okay. So this is the current master concept plan that was approved back 2 years ago, and you can see, and it's a little difficult to see on this scale, but you have a full-size copy in front of you, along with a copy of this PowerPoint and the survey and some other items. But there are the two areas that are proposed for the modification that you can see on the right-hand side is the additional language, adding the, where we will be adding, and I'll show you what the after condition is on that. But where the node is located on the right-hand side, close to the Kimlinghorn logo. And then a little bit further to the left, you see a north-south yellow sliver. That's the area that was also expanded or increased and enhanced. So what does that look like in the proposed condition? The new notes, and there again, I apologize, it's a little difficult to see at this scale, but you do have a copy there, an 11 by 17 copy, so it's very clearly annotated. That the note is referencing the emergency right in. That's also referenced on the inset in the bottom right. And then also, as you can see, the increase or the enhancement of the stormwater in the lake and the open space provisions in that, I'll call it the western portions of the property itself. With your permission, I'd like to hand this over to Ms. Becca Bond at this point to talk through the traffic and transportation.
Yes, give me one moment, because I think you're intending to enter these into the record, and I don't have the sheet that I need to do that, so give me one moment.
Sure.
Maria, do you have these with you?
Madam Hearing Examiner,
Yes.
while we're at a break right now, can
Yes.
I jump in on something?
Yes.
I do have the affidavit of publication for this project.
Okay.
The reason why I'm bringing it up now is just as a point of clarification. Unless the applicant requests that this case goes to the board, that the hearing examiner is the final decision maker on this case.
Okay.
I just wanted to make sure that that was put on the record before we
Thank
get
you.
too
That
far
was
into the case.
not clear in the material, so thank you. Give me one moment so I can get all of this then. All right, so the affidavit will be staff exhibit A. And then staff exhibit 1 will be the staff report with all of its attachments. Okay, and then you indicated, could you go through these again too? I've got the PowerPoint here.
Sure, you should have a hard copy of the full presentation, so the PowerPoint presentation.
Okay, so that will be applicant exhibit 1. And I did receive your 48-hour letter, so that was applicant exhibit A
Yes, ma'am.
for the record. Okay, and then what else do I have?
You should have, at the very back of that should be a boundary survey of the property. That should be the last of the attachments in that group, the 11 by 17s. So you should have 3 11 by 17s.
Yes.
So there is the boundary survey, there should be the proposed or amended master concept plan, and the previously approved concept plan as well.
So I'll take these in order. So I've got the original MCP and the proposed. I'll just do a composite. Actually, I'll just separate those. The original will be applicant exhibit 2. The proposed will be applicant exhibit 3. And just to clarify, that is the same as what I have in the staff report?
Yes, ma'am.
Okay, thank you.
And that is also the same information that's being presented.
Okay, so can we run through those exhibits again, just to make sure I have them?
Yes, so we've got applicant exhibit A was the 48-hour letter. 1 is the PowerPoint. 2 is the original MCP. 3 is the proposed MCP, which is identical to what I have in the record here. And then 4 will be the boundary survey. And that also is the same as what I have in the record?
Yes, ma'am.
Is there clarification? Okay.
And just for the record, that is the same graphic that you saw on the previous slide as well as this slide. And it's also the same in the staff report as well as the exhibits.
Okay. So that is carried throughout, just to be sure.
Yes, ma'am.
Okay, thank you. Okay, thank you. And then on that point, then to get back to staff's point, so it's applicant's intent for this to be a final decision as a minor amendment with the hearing examiner. Okay, thank you. You do have the option up until the end of hearing to make an election if you wish to go to the board, just so everyone knows that. That just has to be done before the end of hearing.
Okay.
Thank you. Okay, thank
Thank you very
you.
much.
Good morning.
Good morning. My name is Becca Bond. I'm the licensed professional engineer, traffic and transportation engineer on this project. Go ahead. So I have 8 years of experience in providing engineering services to both public and private sectors. My expertise falls into transportation planning and traffic operations engineering. I've been previously qualified as an expert before multiple municipalities in Southwest Florida. As Kelly mentioned, which she did a great job of summarizing here, the traffic impact statement that was previously approved with the last rezoning, there's been no change. And this is because the access was accurately reflected within that study. The intent was always to have emergency-only ingress and then resident egress. This was really, vocabulary, text change, nomenclature that was missing on the actual master concept plan. But the study did accurately reflect what had been discussed and did analyze it per the current, proposal. FDOT has jurisdiction over the proposed access that we're discussing today, which is on US 41 Tamiami Trail. We did provide an updated traffic study to FDOT as part of that permitting process, which is currently ongoing. The reason for proposing this type of access is because the FDOT will not allow a resident ingress and egress at this location. So that is due to spacing from the adjacent driveways along US 41. So it does not meet the spacing required for an ingress. So that is why we are proposing that emergency only ingress and then resident egress. This is a zoomed in version of the original current MCP and then the amended MCP, just highlighting where the word emergency was added before each reference to right in. This is just another portion of the MCP, specifically the detail in the bottom right-hand corner of the exhibit. So showing again, it's really just adding that word emergency before the right in. In summary, the traffic analysis, methodology, and procedures were consistent with the administrative code and the traffic study guidelines for plan development rezonings. The traffic analysis results are consistent with lead plan objectives as well as the Land Development Code, Chapter 34. And as mentioned, we have prepared additional detailed traffic analysis as part of the DO process, which is underway, and as part of the DOT permitting process. So that is still in review. We have received comments from FDOT, which we have addressed. So now we're waiting for this to get finalized before we move forward there. One point that we wanted to mention, we concur with the staff report, but we wanted to discuss some wording in condition 5. This is simply, we are here today because of an access modification that couldn't be approved administratively. So we wanted to mention there are currently 3 cross-access points shown to the Pine Lakes community to the south. And this modification would simply state that if it was reduced to fewer than 3 cross-access points, that could be approved administratively. So it's not discussing any increase. We're not proposing a decrease at this time, but if that were to happen in the future, a decrease down between 1 or 3 could be approved administratively.
Okay, so was ADD 2021, that was approved, because that also was one of my questions. When I heard this case the last time, that had not been approved yet. So and it wasn't in the material. So that was approved. So there are 3 access points on Circle Pine, I believe is the name of that road, Circle Pine Road. Okay, so those are existing. And then this access to 41 that we're talking about, has FDOT approved at this point the emergency in and the full resident egress out, or where are you in that?
The permit is not approved, but that this was at their direction. That was the type of access, the geometry of the access, and control of the access that FDOT has requested.
Okay. And I assume, I don't want to interrupt you if you have.
No, you're fine. This was the last slide, so I'm about to hand it off to someone else.
Yes, because this is the crux of the case, right?
Absolutely.
Because when we heard this case the last time, I didn't have that requirement that we come back through the public hearing process for the 41 connection. That was something that the board intended. So I want to be sure that we're continuing the board's intention with that and preserving whatever the protections were that they were trying to keep in place. And so I don't want to undermine that in any way. So if these 3 access points are remaining, what I guess protections can there be that there would be some method of ingress or egress to 41?
Oh, absolutely. And this modification or clarification of wording is not intended for any of the access point on US 41 at all. It is simply related to the 3 cross-access points to the south. If those were to be reduced for any reason to a number less than 3, greater than 1, that would be administrative. So we're not proposing any change to the previous stipulation regarding the US 41 access.
But how does that actually work? And I don't recall if you were involved in the case a few years ago or not, but again, this was the entire crux, right? Was
Yes.
the amount of traffic that was being pushed into the existing community. So if the testimony, because I reviewed all of the transcripts leading up to today, the testimony was that the benefit of the 3 access points is that it would distribute the traffic, no particular segment would feel the full impact of that, and at the time, there was this envisioning that the 41 access was going to be fully functional. So now we're getting rid of the entrance into the community from 41, so we're pushing to be egress only, which I understand, but now if we're pushing the other 3 and now saying maybe it could be reduced even further than that, what traffic analysis have you done, either through the DO process or for this case, to show what that's actually going to look like?
Absolutely. Well, I do want to clarify that the previous traffic study that was approved in 2022, that was, nothing has changed. That analysis was done with assuming no resident ingress off of the new proposed access point on US 41. That language is still in there. So it was analyzed with all ingress and egress traffic through the Pine Lakes gated access point, not through the new proposed, just for the most conservative analysis possible. So that was studied previously, and that has been studied in our updated DOT analysis that's ongoing currently. So I might lean on someone else on our team if we want to talk about the cross access. I know that.
Well, before we get to that, let me just ask you, for the record, in your expert opinion, based on that traffic study, does the main access point work?
Yes, and the main access point does operate adequately, and that's outlined in our previous study and in our updated study.
Okay, and you're reducing the amount of trips that you're generating, but you didn't.
Correct.
You didn't look at what the reduction of the impacts would be on the lower number of the 400 that were.
The DOT study for the permitting process, that does have the reduced number, but it did operate adequately at the full 400 that was previously approved in 2022.
Okay, And just for the record, can you clarify, because the transportation analysis that we have from staff, and I'll ask this of them as well, said that there was no functionality deficiencies happening for level of service standards except for the intersection at Pine Lakes and 41. So what does that look like in terms of what development provisions might be in place to protect against that?
Yeah,
impact?
there's no LOS deficiencies at that intersection per our latest study. There are proposed turn lane extensions. The current existing southbound right turn lane into the property access and the northbound left turn lane, those are not related to any level of service deficiencies or operational deficiencies. That's due to updated FDOT turn lane standards. They've increased based on the posted speed limit and type of roadway. They've increased their lengths of turn lane requirements. So we are proposing extensions with the DOT permit as requested by FDOT. That wasn't previously included as mitigation in the study, but that will be done as part of the permitting process and part of the construction.
Okay, through FDOT or through the
Correct, through FDOT.
Okay. And then can you describe, or someone else maybe, what that entry point or exit point, excuse me, at 41 is going to look like? Is it gated for the residents to exit? Is it free flowing?
Yes, it's gated,
Okay, so
which is part of why we wanted to make sure we could increase those turn lane lengths. And it was studied as a gated access.
okay, so it will be gated for entrance with some kind of knockbox or something for emergency services, and then it'll also be gated for the exit.
I'm gonna look at the client for a nod. Yes, that's accurate.
And there'll be essentially like a gated guardhouse or something there as well?
Okay, for which one? The main one or the one on
This
this
one,
property?
the new one.
Oh, the new one will have a gate, but of course it is exit only. I don't believe there's a proposed guardhouse at the exit gate.
There's not. It would be an automated type gate on the way out.
Well, yeah, if you want to answer, you can come. Just for the record, we need to have everything preserved. I asked because I did the site visit yesterday, so I drove everywhere. I did all the entrances and exits, so it seems like right now there's very nice entry features. They've got guardhouses, and I believe the exit that I took was not gated to exit because I went out a different way than I came in. Because again, I was going through all of it, and I'm just curious what this is going to look like, if it will continue that same pattern.
Yeah, so for the record, my name is Jim Murray, Senior Director of Land Development for Equity Lifestyle Properties, the applicant. So yes, for that emergency right-in, right-out access point to US 41 will be gated on the way in with some type of electronic gate. The specifics would be a Knox box or something for emergency access, and then the right out would be gated as well with some type of sensor that would obviously not allow traffic in, but would open up when a resident's car got close enough to the gate.
Okay, thank you. Okay, that was the extent of my questions. I'll ask staff the rest. Thank you.
Wonderful, thank you. I'm going to hand it off to Peter Van Busker.
Okay, before we do that, you had a question about the 3 access points. That was a PUD amendment because the property to the south isn't a PD, it's a PUD. That was reviewed and approved by the staff, and Mr. Danley can confirm that.
Yes, that happened concurrently, effectively, with the MHPD rezoning. We waited until that MHPD rezoning was done before approving that ADD.
Okay. Thank you.
Thank you.
Good morning.
Good morning. I'm Peter Van Busker with Kimley Horn Associates. I am a licensed professional engineer with the state of Florida. I'm also a certified planner with the AICP. I have been recognized as an expert providing testimony in front of Lee County as a licensed professional engineer, civil engineer, and a certified planner. Today, I just want to go over briefly the change in the lake. You'd correctly pointed out that had we not been here in a public hearing to change the wording for the access, this would have been done administratively. But we knew we were making this change, so we included it with this so that the MCP would show that, and as we're going through the DO process, we would be consistent with the MCP. So we are increasing this lake. Part of it is because as we were starting through the stormwater management plan review with the Water Management District, they pointed out that they would prefer lakes be at least a half an acre. And this was under half an acre, so we expanded it. by expanding it, we did lose one of our roads and our blocks there, but we get a better lake. It provides better stormwater treatment, so there was a benefit all around. And again, the district requested it, so and it's here today just because we're going through this process. From that, I'll go to lead plan consistency. I won't read all these. This is in the PowerPoint that you have. It's part of our submittal that we show our plan consistency, and I think staff will agree that we have a consistent with the lead plan, and it's in their staff report. So I'll just go through these briefly. We are also consistent with the LDC. We are in the DO process right now, so they're reviewing the plan. And then as part of that, of course, we're here to do this MCP amendment so that we're consistent with our MCP as we get our DO approved. So again, I won't read through all these, but we are putting in the record that we are consistent with the LDC. Again, we have findings that we need to meet. We comply with all the findings. I believe staff will agree with that statement. And that is the end of our presentation, and I'd be happy to answer any questions you may have.
It's minor, but can you go back to the one you had where it had the existing and the proposed?
Sure.
I didn't notice it before, but there's a deviation keyed next to the lake, and is there a deviation that's needed there? In the amended MCP, you've got the triangle with the 1, but that's the separation distance deviation.
So on our plans, the Delta 1 would be a modification, a revision to the plan, so it doesn't reflect the deviation. It reflects a modification to the plan. So we've clouded the change and noted it as revision 1 on our plan.
Okay.
So
It looks just like the deviation 1 triangle.
It
so
does.
It's a little.
Does the staff interpret it the same way so we don't create any confusion where we have to come back?
I believe the MCP made note of like an actual description of what it is for the deviation. I gotta pull it up now. Right,
very minor.
the
I have 2 originals.
yeah, you're right. Maybe we should leave the record open to have that
It's
clarified.
very minor, but I don't want to cause a
Right.
problem with that because it's confusing. Okay.
No, I mean, I want clarification so everybody's on the same page.
Yeah, if we need to remove it, is it a problem to remove that? from the-
no, or we could just change a designation. Instead of using the triangle, we could use something else, symbol, and just to note that that is the revision, but not associated with deviation. Okay.
And I didn't notice it until you blew it up so large there, which I
Yep.
appreciate.
No, that
because
was.
These are hard
it's-
to see.
It's a good
otherwise.
point. It's a good point. Yep.
It may be warranted. You do have under the legend, you have deviation request with a circle, but then you show it as a triangle in every other instance. So maybe it's as simple as that. But
Okay.
if you could modify that for clarity.
Yeah, we could modify that, and I would say we could have that into you within the next 48 hours. Okay.
So that's not the latest version of the.
That's right. It was as of 10 minutes ago. Thank you.
Right.
All right, did applicant have any other witnesses?
The applicant has no further witnesses at this time. We do reserve, obviously, the right for rebuttal.
Okay, thank you. If staff is ready to proceed then, thank you. All right, so the staff presentation will be Staff Exhibit 2. Good morning.
Good morning. I tried to keep some notes on some of the questions you were asking the applicant. I think I'm just going to go through our presentation and you can ask them as they come up again. And we can see if we can try to clarify some of the record. I did want to agree with the applicant's representatives that the ADD, the administrative approval for the PUD, We kept it out of this application because those access points are not being rehashed as part of this application. They were germane to the original rezoning because creating that connection was, as you say, one of the most important parts of this whole thing. And so, you know, it was kind of integrated to the last analysis, but wasn't part of this one because at this point that integration has already been created. The application did seek out the change to that emergency in, right out access point, just to give a little more history of, at least as staff remembers going through that case. The first submittal of this application back in 2021 did have that emergency in, right out to begin with. We did take concern over that, and so the TIS did continue on with the analysis of that because that is the worst possible condition for the other access point within the existing Pine Lakes. So their assumptions continued down that path, but we did go through the application with the hope that we could get FDOT to agree to a right in, right out only, as opposed to emergency in, right out. As you know, jurisdictions are a little hard to navigate, particularly at the time of zoning entitlements. But that's why that condition was placed in there. There was an assumption that we could overcome that condition with DOT and then move forward with a right in, right out with that northern piece. As they've gone through the development order process, there's been several cycles now and with staff coordination with FDOT, trying to get to an agreement that we could get that right in, right out. We just couldn't compel FDOT to do that. So at the time of the Board of County Commissioners looking at this, that was one of the sticky points, and there was still not a finite answer from FDOT, and that's why that condition was originally placed in there, and that's why we're here today. So this application was submitted after getting a more finite response from FDOT saying that they were not able to approve a permit to have a right in, right out for that northern tract. The applicant's already accurately stated, and so have you, that the increase of the western lake we would have addressed administratively, but it is part of this application. And then the minor revisions to the internal street layout because of the lake, we would have also considered administratively, but it is part of this request. The applicant's already put together a side-by-side comparison of the two MCPs, but just highlighting the main point of the lake. The access location hasn't changed between the two of them. The wetlands that were previously intended to be preserved will continue to do so. The lake at the rear, which in the first couple iterations through the sufficiency review of the last case, originally intended to have mobile homes in that area, that has since changed and is now accommodating those that water retention for both parts of the project. Then that's, like I said, that was continued on from the last hearing. We kind of hashed out that in the first round of review of this case, but that's remained the same. So effectively, the only footprint change was the lake and the extra road that the applicant stated, and everything else is generally consistent between the two projects. We have a slide layer that lists out the ADD that approved the connection points. Those have not changed. They've not been realigned or anything else as part of this request. It's that ADD 21-147. That's what originally approved those northern connections to the new Pine Lakes extension. This is just the decision-making criteria. The staff report itself was somewhat limited in scope as a review, because the remainder of the project is generally consistent with its previous iteration, with the exception of that connection point, or that ingress and egress on 41. As we stated before, the wetlands future land use category, the wetlands on the property are intended to be retained. The property is still generally consistent with the suburban future land use category. We still find that they are consistent with objectives 2.1 and 2.2. We still find them consistent with 5.1.2 and 5.1.5. And going back to, in terms of preservation of of the character of that neighborhood. As we stated before, the TIS did assume worst case scenario, so the conditions really haven't changed in the assumptions that were originally considered. And so we still find them generally consistent with that. This does ensure a mix of housing throughout Lee County, and particularly in this area. Affordability is always a concern, and staff does find this request still consistent with 30.1 and Goal 135. We talked about the wetlands and the stormwater ponds throughout the area. We do find them consistent with 125.1.2, and we do find them overall consistent or with the decision-making criteria for plan developments and amendments. And we do recommend approval with this case. I did want to put on the record, you did bring up the TIS and the memo provided by staff. That reflects the same comments that were made in that previous zoning. The eastbound movements out of the main Pine Lakes access is considered an F. We have a jurisdiction issue with that road. The applicant did talk about the extension of the turn lanes in the area, but because it's a state road, staff hasn't had a strong opinion on how to resolve that because it's not quite their jurisdiction. So through the development order process, they are looking at improvements that can be made on the private side of that development. But as long as that northern access is there, that still gives a relief valve if something was, because that eastbound movement is to get out of Pine Lakes. And so if the retention of a second access point still gives a driver an option to get in and out of the site if additional congestion renders that access point a frustration or a safety problem.
The proposed condition change that they just presented, have you reviewed that and have?
Yeah, and we're generally in agreement with it. You asked a question about kind of the spreading out of traffic on that road. It all empties out onto the same road. They all take the same path into that eastern access point. And we wouldn't find an issue if it went down from 3 points to 2 points. They would generally have the same impact on the roadway. And I don't want to speak for the traffic expert, but generally less conflict points is generally an improved condition. I can let them speak on that if they want to at the time of rebuttal.
Thank you.
Okay.
Did the applicant have any questions?
No, I don't. Thank you.
Thank you. All right, so I'm going to open public comment, and I will call the cards in the order that I have them. First card that I have is for Linda Baker. No, thank you. You didn't want to speak? Okay. Next, I have Linda LeClaire. Good morning, ma'am.
Good morning. I hate being first. Okay, I strongly object to the resident out. Of course, that brings an additional up to 672 vehicles. If there's 336 new homes, there's a possibility of 672 new vehicles coming in and out. This is already an extremely congested, dangerous road in and out. The turning lanes, I understand they're proposing extensions to the turning lanes. That's what I just heard. We would need a turning lane that's going to go down to the next community to accommodate this many new vehicles. The access road with the proposed the roads here, the 3 roads on the south, there's still a question as to whether ELS owns Pine Lakes Circle Pine Road there, or whether it is owned by the estate landowners. I guess that's all I have according to my notes, but okay, thank you.
Thank you for coming today. Okay, the next card I have is for, excuse me, Ron Thorson. I apologize. Good morning.
Thank you, Your Honor, and I'm glad to be back after almost 3 years. I had a very large PowerPoint presentation, and I brought none of that today. And there's a real reason why, is that a lot of changes, as you spoke of, happened since that December 2021 hearing. And so I'm going to kind of try to go over some of those as we speak. First off, I am a member, and I'm an elected member to the Homeowners Association Board of Directors for leased land. And I think you're aware that there are 2 homeowners associations. And by the way, thank you for coming and touring, because the visual helps a lot, I think, when we talk about what's going on. So, and obviously what we're hearing, and my first question is why is this here anyway? Because what, on their very first application, the verbiage was there, that it would be a emergency exit in. That was part of their permitting, the first thing. And out, so I just didn't know why we were going through this in a public type hearing. But that's, as I've listened, I've got into a few things. So let me just get my notes a little bit better here. A couple things happened at the zoning hearing that has to do with the access road that we talked about, the 3 spots there. Ms. Bev Grady was an attorney. She retired now. But she brought forth the fact that Mr. Brown, the original designer and developer of this property, had put, and it's in writing, I have the number on the plot map that, and I can read the language if you want, that, and I think I'm going to, so please give me a moment to try to find it. I didn't know the design. Oh, here. It's how that goes sometimes. Anyway, it basically grants the estate property the rights to use it in perpetuity, and they were responsible for the road maintenance at the time when it was developed. I believe ELS purchased the property in '94, or a subsequent company that's listed on there.
I'm going to pose an objection at this point in time. One is hearsay of Bev Grady's legal testimony, I believe, and secondly, he's talking about something not within the 4 corners of the application.
Has to that point, I assume, because it came up on the first hearing too, that the road ownership question has been resolved at this point legally?
Well,
There were several things that were, I mean, the county staff and again, I've got to limit this. We had this problem the first time with going outside of matters that I can consider in the request today. So the request that the county is looking at is whether there's sufficient access to support the development. So county staff, I assume, has reviewed whatever was provided and come to that conclusion.
At the board hearing that was discussed earlier in this hearing, the county attorney's office opined that that was a data-related issue on the ownership of a road, seeing as that could be addressed or adjusted at the time outside of a public hearing. My understanding is they're still working out the finality of that at time of development order. They gave us some information as part of this application to give us confidence that they were sorting out that issue at the time of development order, but I don't think that we've come to a final conclusion on that.
Okay. So
that's why the presentation is important. And let me explain, because there are contracts and things before. In 2002, the estate homeowners and the ownership had a dispute, and part of it was based on the fact that the estate owners didn't pay for amenities in, and they claimed they were responsible for the roads. So in a 20-year contract agreed by both ELS and the state owners, they've asked that the state, or that the owners maintain the roads, and then they in turn pay a fee for some amenities. And that contract would have expired in 2002. It wouldn't expire. That was the time. At 2022, and there's an automatic 5-year extension in that. But let's get this more deeply. You have a plot map that has them as a responsibility. And if this contract goes away, either one of the parties walk away from it, 27, going to refer back to what's on public record, and it will show that the estate property owners have an interest in those roads. Yet they haven't been consulted, they haven't been talked to, and so all of this is the tension point. And the frustration of residents. We know that after this hearing, we're going to meet in a large group. I'm sorry that we didn't have as many here. I think you remember what we had at that hearing. We've got early season, that was in December. We have the bridge construction, and so a lot of that, I can assure you that we have a communication throughout our whole community, that everyone in the community is aware. And I'll go back to my testimony back in those, at the December one. I said, I'll speak for most of them because I think I can. The vast majority of people have no problem with the development as long as it doesn't use our roads and it doesn't use our amenities. And the intent of this has been since 2018, actually. Originally, ELS came, I think they talked to the matriarch of the ownership of the elderly lady that owned the French property, and they came to us and said, what would you like from us? They actually wanted us to sign a letter of cooperation, and both HOAs refused to do that. This is in 2018. Master concept plan is basically the same. It had 4 entrances because in the back, of course, that was a part of that had property in the far west portion. So those have been listed from the very beginning. And please hear me out, but this started out as called Pine Lakes 2. The LLC or whatever now is called Pine Lakes Expansion. Now, I don't know how we're expanding in a agricultural property, and so I questioned it. They formed that organization in Delaware. It's part of ELS a year and a half ago, and now they call it Pine Lakes Expansion to give the perception that our group is expanding into here. And then I'll tell you that I'm an at-large director for the Federation of Manufactured Homeowners Association. It's the only state-recognized organization. It's a consumer advocate for people who own manufactured homes. And in 2020, the management organization, FMHA, went through the legislature and made some changes, and one of them which that a 15% addition to any manufactured home community on leased land was acceptable.
I think that she's
I'm
about to
gonna-
object, I know, because we're again getting outside the scope of what we can hear. So and I heard you the first time, and I appreciate all the frustrations that are going on, and I'm aware that back then there was civil litigation that was happening, or maybe administrative issues that were happening in the legal realm outside of the hearing. I don't know the status of those, and I can't know the status of those. That's not my purview. So
Yeah.
just the comments today just need to be limited to the access and the change in the lake configuration and the roadway. That's all we can
And I
talk
understand.
about.
You were very patient at 2.5 years or almost 3 years ago. But it's important details that, and this is another thing that happened after your hearing, when the zoning commissioners made the ruling, they also added in that would be fully compliant with 723. So that's another, I believe, and Dirk might be, I believe in that the ad was approved in August after the hearing. That's the documentation we have. And let me see. Let me go back here just a minute here. I knew that this was going to be one of those, and I respect the fact that there's questions of it being outside the scope. But a number of these things have pertinence to expansion. Okay, so,
And I appreciate that. I don't want to interrupt you again, sir. I appreciate that. The issue is that issue of expansion, that was approved by the board 2 years ago, 3 years ago. So they've already said that the community is fine, it's compliant, it's consistent. We can't relitigate that issue. The issue today is solely related to the access on US 41 and the reconfiguring the lake on the western side. So
Those-
that's the scope.
those 3 entrances, exits are access issues.
Right.
And that falls into combination of properties. So, again, though, what's going to go on is this, is that depending on how this hearing, and I really encourage you to look up the plot map. I think it's on file after the
I'm
zoning
going to
meeting.
object to that because the hearing examiner is limited to the testimony and the evidence that comes in during the hearing and what she gleans from her site visit. She's not allowed to, as far as I understand, engage in research projects. So I'm going to
That is the, and
put
again,
that in
that's
the
why I
record.
keep repeating it, and I apologize to keep interrupting you. I don't like to do that, but I do just, but the narrow, it's a very narrow scope on this case because the majority of those issues have either been resolved through the board's adoption of the zoning resolution or are outside the scope of what they could even consider. So those issues, I don't question the legitimacy of them, and I don't want you to feel that way, but they're simply not appropriate for this proceeding. So I understand it's all related, but it really, whatever testimony or evidence you have needs to be related to the access.
The most important part of this is that your hearing, when we talked about various options for entrance exit, I had been trying to get a copy of the blueprint that they use for a template to put these roads on. And actually you held it up and said, I think I have it here, the original one. It had all the writing, so forth. And so you sent it to me. We had a day and a half hearing. You sent it to me on Thursday. I got it, opened it up. And of course, more evidence of options that weren't presented in the HEX hearing now became to us by the whole legend in that blueprint that you sent me. Showed about a frontage road and access to the frontage road. And it even went into the detail about taking out the border or the concrete signage and who would pay for it. Very great detail. I was in construction. That's the notes usually give you the evidence as you're asking about the different signage. So that in itself we couldn't present in your process because it was already closed. And again, we go back to, we get to the zoning hearing, we find more evidence.
I'm sorry. I know you, I perceive you didn't like the outcome of the board's action on the zoning, but we're not allowed to relitigate or rehear that today. We have to talk about what your comments are on the expanded lake and what your comments are in regard to the emergency in, right out. That's it.
Don't you have a rule here too that the speaker's supposed to be able to complete their, and then have rebuttal afterwards?
You can, but it has to be relevant, and that's the struggle that we're having, is that I can't hear, it's not appropriate for me to hear the testimony of things that are outside the scope of what we're supposed to be hearing today. So that's where this, and I understand it's a blurry line and it feels that way, but we.
I did go see Brian Hammond afterwards, and that was another frustration that we're restricted to be able to not speak to our elected officials during the process. And I, being elected, I was elected 3 terms and city councilor, so I've been on the side of listening to what goes on here. And that was appalling to us. And we had a good half-hour conversation. And he had people from planning in there. And one of his comments was that, well, he sounds like you have to pursue legal matters. Now, I've been a great advocate of using the governmental process to be heard. I'm kind of appalled that the statutes are so narrow in this to not address the very important things. I'll go right to the roads. I mean, I'll ask Mr. Danley maybe to describe what an ad is, and I believe I'll use words as very minor, not a big decision. Yet right now, with all the things that got on, 100% of that property is going into those entrances. And so the ad decision itself is questionable, and we may have to go and look to get a judge and jury's opinion on even the access and so forth. So the frustration here is that we want to be heard, and we want the questions to be asked that are correct. And if there's, as Mr. Downey says, there's still questions on the road, I'm submitting the evidence of what was put into the zoning. That's our point. It's very simple. I would suggest that ELS maybe try and talk with the residents about it. There's a possibility that something might be able to be worked out. But without any of that, because they do the same thing, we only talk about this. it's, the residents will meet en masse soon, and we'll make a decision based on what happens here. I mean, I was hoping that this would get referred back to the, I mean, it's a real big deal that the road isn't decided on yet. So, thank you very much for your time. I appreciate it.
Thank you for coming today. The next card I have is for Beverly Thorson. Good morning.
Good morning. I do think that Ron's presentation just reminds you and the general public that there is a concern over what is going to happen. I live in Pine Lakes. I see how long it takes me to get to the guard shack. And if you're going to add another, 300, 500 cars, not sure how that's truly going to work. It just seems like a real frustration, and that entrance that is proposed for emergency only, I just don't get it, and just residents can exit. I can't understand why there can't be then an entrance in that area for residents to get into their property. If I were to purchase a home in this new development and had to go through another old development with old roads and not good access. There are no roads there now. Those 3 little arrows are just little arrows. There's really drainage ditches, and there are no roads. We have no sidewalks. I can't imagine what it would be like to add to that. So even though some of these things might not be pertinent today, it is something that the residents really do worry about. Thank you.
Thank you for coming today. The next card I have is for Wayne Albers.
No,
Thank you. Okay. Okay, Stephen Falk.
My name is Stephen Falk, and I live in Pine Lakes on Indigo Court. The big problem here with the access is you're going to take 300 to 600 more houses or cars. You got 336, so maybe everyone has 2 cars. You drove there, you said, the other day. And so you came in here, and you went off the little cutoff right here, right through the gate, right? And you saw that cutoff comes to about here. They say they're going to extend it. We went to the last meeting, they're going to extend it. But they can only extend it another maybe 100 feet because there's another cutoff that goes in this way. So maybe you shut that cutoff off and you just say we're going to go. But add 600 cars to coming through the single gate, and the space between the gate and 41 is enough for about, well, you were there, what, 15 cars maybe, 10 cars? Okay. Then what happens to these cars and all that? Maybe 5 cars? Okay, well, you were there, you saw it. So that's my layman's concern, that you're going to add possibly 600 vehicles, and you're not going to get in the entrance with 600 more cars. And again, it goes back to what, and then DOT says, well, you can't put an entrance in there because of what? Because of traffic problems, okay? And the exit coming out, they also have a church up here. So Sundays and Wednesdays, the state trooper parks up there, which the church pays for, to stop the traffic coming from the north so that people in the church can get out. So what if in the morning, if all these people are working, I don't know if there's going to be an age restriction or not on the community, but if those are working people, and like we all came out to work today to this place, and we're backed up, what if there's 10, 15 cars coming out? It just, we have the DOT engineers and all these guys and all their stuff, but if you saw it and I saw it, it's a problem. That's the dilemma. It's a safety issue, and I think that's the biggest headache here. We got all kinds of legal mumbo jumbo going on, but it's a safety problem, putting all those cars going in. So you got only one in, and again, I will go one more quick point. The community was originally designed, obviously, I guess they had traffic surveys and all that kind of stuff, and they said, okay, for this size community with 800 homes, this is going to be adequate, this little cutoff here. It's going to be adequate for 800. They didn't consider adding another 300 homes for that little entranceway. Now, DOT studies, or somebody can count the cars. You came in the middle of the summer, I lived here in the summer and the winter, and in the winter, we almost double our population. So it's safety. It's safety. So that needs to be solved, I think, better than just saying we're going to extend the on-ramp or the entrance into the community by a couple hundred feet. Okay? Thank you very much.
Thank you. Thank you for coming today.
Did I hit all my points, Dave? What did I miss? What did I miss? Oh, the roads. No, we already talked, guys.
And that the police stopped
I
the
did.
church.
I did.
No, but they also stopped the people coming in.
Okay. I did. I mentioned the church. You got it.
That was the last card that I had. Was there anyone else that wanted to speak from the public? Okay, no, so we'll close it and come back to rebuttal. Do you need time before we begin?
I want you to address whether there is or isn't a safety issue, if you would.
Sure. Hello again, Becca Bond, licensed professional engineer, traffic transportation engineer on this project. I want to discuss the reason why FDOT will not allow an ingress at that point. So the proposed driveway connection, as you can see, for this property, the frontage along US 41 is limited. The access has been pushed as far south as possible to allow for maximum spacing from the upstream driveway, which is that church driveway. So the minimum based on Class 3 spacing standards, that's a DOT designation, there must be a minimum spacing of 660 feet for roadways with a speed limit greater than 45 miles an hour. That is safety related. That is to allow for appropriate turn lanes to be placed at the driveways if there was like resident ingress. And this current spacing is much less than that and would not allow for appropriate spacing, would cause conflict between the driveways, and there wouldn't be enough space for a turn lane for that ingress movement at that driveway.
414 feet that's denoted on the master concept plan.
I'm gonna lean on
Assuming
Peter.
It's the entrance to Trinity Enterprise Holdings. It shows that as the distance to the proposed 41.
I'll verify. I don't wanna guess on the record.
It shows 414 for that distance and then 639 from the proposed entrance to the existing Pine Lakes Country Club.
Yes, that's correct.
Is that correct? Okay. Thank you. Continue.
Absolutely. So that's the reasoning behind not allowing the ingress. FDOT sets these standards based on safety requirements, and that is the reason for that. Now, to talk about, there's, without getting too into the weeds, I can if you'd like me to, but there is a standard trip generation per unit for different land use codes. This one specifically, with the mobile home trip generation, we anticipate, this is an industry standard, 192 p.m. peak hour trips. So that is the heaviest hour of the day. That's how many trips are anticipated. 101 of those would be that northbound left movement that was just discussed. What that translates to is in 1 hour, that's less than 2 vehicles a minute that would be utilizing that northbound left turn lane. So yes, it can sound like a lot, but these people are not all coming at the exact same instant, the exact same moment. So we do models. This isn't just, I do this quick math and I'd say, oh, we can extend it by 2 vehicles, that's 50 feet. No, this is a model that's run. We input all of this traffic in, we collected counts, we have modeled it. That's how we base our analysis. However, I did want to just point that out by some quick math. That is what's anticipated. So I hope that provides some ease and some understanding.
And then with respect to the access, because access is the crux of it, so it gets very tricky. It's a
Yes.
slippery slope to talk about one without talking about the other.
Absolutely.
So the proposed condition 5 changes that you want to see is to no longer require the 3 accesses, but to allow up to 3.
No, I believe it's just, I don't think any change is proposed currently. And that's my understanding. I'm going to lean on the civil engineer for this, but.
I thought the slide that you showed had alternate language to what's exists.
So just a note for the record, the development order plan that is in does have 3 access points on the south. Okay, so we're not asking to reduce them. The point of that condition would be for whatever reason, if one could not be constructed and we had to drop to 2, that we wouldn't have to come back here again in front of the hearing examiner to get that changed in the language in the MPD.
Okay. Okay. So the substance of the condition remains the same. It's just a clarification or an edification about the process if something needs to be changed. And that DO, did you already go to the community meetings for the DO? Has that happened yet? Since you're in North Fort Myers, there's a community meeting that's required.
I'm seeing a nod, yes.
Okay, yes, so that's already gone through. Okay, and then when you look at it, again, because that's the road, I don't know who, are you gonna speak about the road owner? I don't need to get into the weeds of the road ownership, but again, the finding is that there's sufficient access. So if access to 41 is not yet guaranteed, is there a legal right to access this community? That's a fair question in this hearing.
Well-
So who do we have that can talk about that?
We'll have Mr. Murray respond to that.
Thank you. Because that's my concern. This gets real tricky with FDOT when we're relying, and this is not that case, but typically, if you've got FDOT is your only source of access, then that's pretty clear. They usually grant the access in that case, right? Because they're not going to leave you without it. In this case, you're saying you've got alternate access. The county is requiring me to find that you've got sufficient access, and so I need some assurance that that's the case if there's disputes that are happening everywhere. And I'm understanding staff is saying the DO can't be issued until that's determined, so I don't need to get into the weeds about what documents, I can't accept those in terms of the deeds about how that got transferred, but I just need some evidence in the record that says that you have the right to access these roads.
Yeah, based on all our review on the surveys of our property and all the existing easements that are within our existing property, we own and maintain the right-of-ways that get to those 3 access points that are shown on this drawing.
The Circle Pine Road and then however that works to transact out.
Pine Lakes Boulevard, which connects to Circle Pine Road.
Okay, and that is, I'm assuming, being required as part of the DO, that you're having to show that as well, and it's being reviewed
I believe so, yes.
in greater detail at that stage? Okay, so no development permits are going to be issued until legal access is shown to exist, is what I'm understanding.
That's my understanding as well.
Okay. Okay, thank you. Was there anything else that the applicant wanted to put on rebuttal?
No, I think we've responded to the main concern that I heard from the residents. If you have another question we haven't answered beyond the one you just asked, let us
That's the big
know.
one. Did staff have anything further that you can add to that?
Just the fact that the development order process, even though typically zoning staff isn't a participant in that, we have been, because this has been a very tricky case, and we want to make sure that the community is represented in the best way possible. My understanding is, even as of the last insufficiency letter with the development order, they're still asking the question. They have been providing some information. Like I said, our last insufficiency letter, we actually basically included the same comment from the development order saying, hey, this is still important to us. They provided us some information at the last sufficiency round, basically showing us that they're working towards making an ironclad guarantee of that. But I don't think that has translated necessarily into the development order being issued yet. Mostly because they're waiting on this amendment to go through, I think. But we have been working with development order staff, or development services staff, to make sure that this is something that doesn't get erroneously approved.
Okay, so the development order will not be approved until they can demonstrate sufficient access and legal right to access the road.
Correct.
Yeah, just as I know you know, for the development order process, they have a legal review. We have to have a survey, and based on the survey, there's a title opinion, and regrettably these days it takes more than 1 or 2 times often to get the title approved. So while we're in process, and I understand that, it's not unusual at this juncture to have questions on some of the legal issues. And yes, we'll have to resolve that before the DO will get issued.
That was the extent of my questions, again, because the scope is so limited at this stage. Did you still want the hearing to be final with me, or do you want it to go to the board?
Pardon?
Do you want this matter to go to the board or to be final with me?
We didn't talk about that.
You have to make the election before the close of hearing today, so I just
Can we
want to.
take a 5-minute break so can
Yes,
I
we can.
make sure?
So we will take.
I have an opinion, but mine may not count, so.
Certainly.
Can I make one more comment about the in and out?
I'm sorry.
If I take Linda's space?
I'm sorry, I
okay?
can't accept that, sir. Once we close it, thank you, though, I'm sorry. Feel free to talk to staff or the applicant on break if you'd like, but we've got a 5-minute break, so we'll come back at 10:15. Okay, we are back on the record.
Thank you for giving it that time.
Yes.
I realized it wouldn't be good for me to make a unilateral decision, so we are going to accept your opinion as the final decision.
Okay. Okay, so procedurally, folks, what that means is I had made comments at the beginning. I thought this was going to be going to the board after me, but rather it will be final with me. The Land Development Code allows them the opportunity to make that election. So again, if you filled out a card, even if you did not speak, you'll receive a copy of my decision once it's released. Thank you, everyone, for coming today. Please stay safe and stay well, and be very, very careful out there. Thank you.
Thank you.
Thank you.